Okay, when you're ready.
Analytical LLC versus Anthony Baker Jr. et al. Case number 220141117CH.
Morning, council. Appearance for the record.
Kathleen Brock, Your Honor, P 78404 on behalf of Analytical LLC.
Okay, and this is your motion for default judgment against Anthony Baker, correct?
Well, actually, Your Honor, it's against all of the defendants
Okay,
that were listed. It was
Anthony,
Anthony Baker, Paris Rumley, Dress Owens, WMC Mortgage Corporation, and Thawaba CJ. I'm not really good at pronouncing that last name.
SAIJE.
Yes.
Okay, could you give me a little bit of background before
Sure.
I get additional information?
Yeah, this was filed, at first of all, there was a problem with the title. There's been fraud on the title, so it is a quiet title action. In addition, when this property was bought, it was bought from the Wayne County Treasurer. Analytical bought it from them. So some of these defendants are actually from the Wayne County Treasurer. So we have a mix here of going on. The Dress Owens and Thawaba CJ and the mortgage company were all part of the Wayne County Treasurer foreclosure for taxes on it. So a lot of times we cannot get title insurance on properties because the title companies do not take the foreclosure. They go back and say you have to do a quiet title action separately. So that's we were doing that as part of this case. And then Anthony Baker and Paris Rumley, there was deed fraud on the case. So that's what we were doing. In addition to that part, there was a second part. Paris Rumley actually was moved into the property based on a lease. So Analytico is actually owned by a gentleman who lives in Ireland. And he has a personal friend that he hires here, and he's also his property manager. His name is John Parowinski. He actually was the one who leased the property to Paris Rumley. And that he was also asking for a money judgment because there was a lease in place and rent has only been paid for 2 months on the lease. And she has been in the property the whole entire time since then. So that was the background of the case.
Okay, but I guess I'm concerned why we're including the Wayne County employee.
The Wayne County.
I thought you indicated that.
We're including defendants that were foreclosed on in the Wayne County tax foreclosure. Yes, because we have two things. We're trying to clean up the title completely to get marketable title. We also had deed fraud on the title. So that's where we're going with the quiet title. And in order to clean up the title, unfortunately, we have to sue the prior people on the Wayne County Treasurer foreclosure list, unfortunately. The banks require that.
So that's the Dress Owens and the
mortgage company and Thawaba CJ.
Okay.
Your Honor, can I speak? My service was kind of out and I had to come pull around the corner from my house.
You need to just state your name for now.
My name is Paris Rumley.
Okay. All right.
Yes, ma'am. I'll mute.
Good. Okay, Ms. Parker.
Yes. So at this time, two things we're asking for: a default judgment, one for quiet title, and the other one would be for the unpaid rent on the property. So the quiet title action itself, if I just walk through each person, we'll start with Mr. Baker. Mr. Baker was served by publication and registered mail. He was served on March 15th. He was defaulted on May 9th, and there's been no action taken since then. And he is just a party to the quiet title action.
Okay, was he served with notice of this default judgment?
Yes, he was. Everyone was actually served with that, Your Honor. I had made a mistake and I resent it out the next day. And I will tell you, that was about 2 weeks ago. Give me 1 second. Yeah, that was served on July 5th, Your Honor. Everyone, I originally made a mistake on the notice of hearing, so I sent out an amended one on July 5th.
Okay.
The next defendant was Paris Rumley. She was personally served at her address on December 3rd. There was a default notice sent out on February 8th. And up until she put in a motion, and I responded to it on July 18th. So there is a motion out there, but the default hasn't been set aside. The next defendant is Duress Owens. That person was served by registered mail and by publication, and that was done on April 12th. There was a default on May 9th in 2023 for failure to plead. He, I believe, was the prior owner to the foreclosure. Okay. The defendant, WMC Mortgage.
And you served everyone with notice of the default judgment on July 5th.
Yes.
Is that
Yes, Your Honor. Everyone.
okay?
I did actually file that with the courts too, Your Honor.
Okay, great.
Okay. The default, for the mortgage company, they have not kept up their registered address. So the way they were served, though, was by registered mail out to their address in Woodland Hills in California, and also to the state of Michigan. And then they were defaulted, Your Honor, on February 8th. And Thawaba Sejay, who is still located in Dearborn, was served by registered mail and attaching the summons and the complaint to the address on March 1st. And he was defaulted on June 23rd. And yes, everyone was served of the notice of this hearing on July 5th via first class mail.
Okay, so you indicated that relative to the quiet title, who do we have? I know you indicated Anthony Baker. So in terms of the quiet title, is it everyone or who's involved?
It is everyone, Your Honor. Yes.
Okay. So everyone is involved with the quiet title. And then of course, just Ms. Rumley as to the
Money judgment.
money judgment.
Yes.
All right. Okay. Ms. Rumley, I'm sorry, Ms. Rumley. The thing
Yes, Your Honor.
that you didn't respond to the motion, was it a motion to, hold on, was Ms.
I responded to the motion. I have my receipts where I'm sorry, I'm in my car because I had to come because I didn't have service because of the power. I have served
You're breaking up, Ms. Rumley, I cannot hear you. You're breaking up.
Can you hear me now?
No.
Can you hear me now? Okay, 1 second. Let me
Yes.
move over. Okay, can you hear me now?
Yes.
Okay, I have served her, which I have receipts. I served her certified mail. I also have responded to my summons, which I can show you. I took pictures of it. She never sent me anything. It was a guy that came to my house one time back in December. He came and brought me a packet. After that, I never was presented with anything from the attorney, which is John's personal attorney. I never was presented with anything from this attorney. John, which is the guy, he never had a for rent sign at this property. I went to visit one of his properties. John presented a lease, which had the date of 4/1/2020 until 3/1/2020, which is an inaccurate date. He also stated on this lease, as you can see, that he was the owner. Okay. He also came and swore with an affidavit that he was the property manager. From that point on, he already lied about the property. I went to see a property on Fielding Street, which is a couple of blocks over from Vine. He never had a sign. I told him that property was too little. I'm a full-time 3.8 nursing student. I told him that the property was too small for my children. So he said, well, I have a property a couple of blocks over that I can sell. He said, but I have to make sure when I sell it to someone that it is the person is going to take care of it. I said, okay, let's go look at it. When I got to the property had no doors, Your Honor. It had no windows.
Okay, which
Which
property,
I can show
excuse
you.
me, what property are you talking about?
7336 Vaughn. From there on, we made an agreement that I would stay in the property for 4 months and pay rent. He will have the people come and put the doors and everything on. Anthony and Mike is two other guys. One of the guys is not on this thing. The other people, I don't even know nothing about. I don't know none of these people, Your Honor. This man has scammed me from the gate. He's made an inaccurate statement. He said that he was the owner, and then he swore before the judge that he was the property manager, which is stated, and he sent a copy of that to you. Also, Your Honor, this title, this deed is stamped and signed and recorded by 400 Monroe. Also, Your Honor, I have that right here.
Okay, wait, let's stop. You getting too far ahead of
Okay.
yourself.
Okay.
I was looking at this and Ms. Parks, she does, I see an answer to the.
I answered to my summons. I can send you, and I also
Hold
sent
on.
it to her. That's your courtroom with my summons.
Okay, well, wait. No, see, you probably didn't properly serve. It doesn't come to my courtroom. You have to follow with the court clerk.
They told me to, I did. I came down, and actually I can show you that as well. I came down, and they also gave me, they printed out these little stickers, and they said that I had to have those on there because it was somebody in the e-filing department and using the kiosk. They printed out these stickers. I'm sorry, I was organized, but I had to leave out the house because it wasn't connecting, and I didn't want to miss. She printed out these stickers, and she said that I had to put those stickers like on there so that you can see it like labels. So
Okay, so once you put, okay, hold on. Once you put the stickers on the
courtroom, the
label,
lady helped me.
wait, hold on. Once you
Then
put the
she,
stick, hold on. Once you put the
okay,
stickers on it, did you take it back down to the second floor? You're not supposed to bring anything
yes,
to the courtroom. So you're saying you placed it in the court on the second floor? You
yes,
placed
and
it-
then she
When was
also
that?
put it in a stamp.
When was that?
I can tell you the exact date because it's on here. That was 7/5/2023, and also that was when I did it the first. That was 7/5/2023, and the first date when I sent this to you was where's that paper that I just had for you? Because it's on here.
Because you were served in December. You didn't respond initially after you were served
Yeah.
in
Yes, I
December?
did. I'm trying to find the paperwork that I had sent to you that I just had. I'm just a little all over the place because I just had to leave out the house to get service. I'm sorry. The paper that I just showed
Okay,
you
you know
had
what?
the
Hold
date
on,
on it.
hold on one second. Hold on one second.
Mhm,
Hold on one second.
mhm.
Ms. Park, let's deal with all the
Okay.
other parties first.
Thank you, Your Honor.
Okay, so you have the there was something else. And did you attach an affidavit, Ms. Park?
I attached an affidavit in the original complaint for John Powinski.
What is that under let me see where it's in. Which exhibit is the complaint again?
I believe it's exhibit, I'm looking.
I see it.
But that was just for the breach of contract.
So I see the exhibit attached to file complaint. So was it attached to that? That's exhibit
Yes, Your Honor.
A is the warranty fee. Exhibit B is another deed. Exhibit C is a mortgage.
Your Honor, it's like 5 people that it's like 62
Okay.
people claiming to own this property, and I've been here since 2020,
Hold
owning it
on,
and paying property taxes.
hold on. We're not even there.
Yes,
So
ma'am. Yes, ma'am.
I see all of these different deeds allegedly.
Yeah, yes, Your Honor, the
Okay.
deeds were there for, to show the title. And
Okay,
the
I'm trying to find the affidavit.
and I'm looking for it too, Your Honor. I believe I just found it. The lease
Your Honor, it's right
was
here.
in
No, hold on, Miss. I gotta look at it myself, Miss Rumley. Give me a second.
the,
I do see it. I see it's at the behind Exhibit L.
yes, sorry.
He indicated that he was a property manager. And he visited the property February 2020. That was when he said he didn't get the name.
Your Honor, in my lease, it states that he's the owner, which he really
Oh,
was.
okay, hold on. I'm not even there yet. We're not getting to the facts yet. This is nowhere near the facts. This is all
Okay.
procedural today. This is all procedural.
Yes, ma'am.
Okay,
Wow.
so what I wanted to do first, let's do, as I indicated, we're going to deal with the other parties in terms of the quiet title as to Anthony Baker, and you're gonna have to note this because, like I said, for each person it's different. So the court would grant quiet title against Anthony Baker. And that's Duress Owens, correct?
Yes, Your Honor.
Saaba Saje, Siaje. Now, tell me, in terms of the mortgage company, did they offer extend a mortgage?
They had a mortgage that was never, it had been a mortgage for a long time ago. It had never been, oh God, the word I'm looking for, it's
They never.
discharged.
Okay.
It never been discharged. So
Okay, so as to WMC mortgage, as to Anthony Baker, Duress Owens, Waba CJ, Sajay, and WMC mortgage, the court will grant the default judgment quiet in title. Okay, now the only thing I need to know, and I'm looking for it, is that did she answer the complaint?
I was never given an answer to the complaint, Your Honor. I was served with her motion to have the default set aside, but there was not an answer in the complaint or in the motion either.
Okay, so did Ms. Clifton, did we? I don't know, you can't hear me. Did we properly receive was the motion for default to set aside default properly presented? I'm trying to figure it out. Okay, so she does have a motion to set aside the default. Would do so, and Ms. Rumbley, you're gonna have to call call my law clerk. I can't hear you. I cannot hear you, Ms.
Okay. Because I don't have a quiet title. I don't have a quiet title. Can you hear me now? Can you hear
Yeah.
me now?
But
Can
you
hear me
still
now?
have to think, yes, but the thing is you still have to
Can you hear
answer
me
the
now?
complaint. Yes, can you hear me? Okay, Miss,
Hello?
yes, I can hear you.
Okay. I don't have a
Mm.
I'm registered and recorded at 400 Monroe. Yes.
Miss Brock, now as to Miss Rumbley, is it just,
And I've also been paying the property
Hold-
taxes for this property.
hold on one second, please.
Since 2020.
You're breaking up, hold on, you're breaking
Matter of
up.
fact, since 2020.
Okay, hold on, Miss Rumley. because you're breaking up and I can't hear you. Give me a second. Ms. Brock, as to Ms. Rumbly, is it the quiet title and was she involved in the ownership interest of this property? Or is it just is it the
Oh, no, it's quiet title too. Her deed comes from Anthony Baker.
okay. All right.
And then
Okay.
there was the
Okay. So, but what I was getting ready to say is, I'm not going to enter a default against you today because you did file a motion. And I hope you can hear me, Ms. Rum, because I'm not going to repeat this. Your recipe was not correct. You need to call the courtroom to schedule to get an understanding of how we had a hard copy, right, Kim? We had a hard copy, right? But it just was not a recipe. So the thing is, Ms. Rumley, you need to determine how to correct your recipe. Call my law clerk. Have you talked with anybody in the courtroom? Ms. Rumley. Ms. Rumley. So, like I said, Ms. Park, as I indicated, we're going to enter the default judgment against all those parties the court named. And at this time, the court is going to
Yes, can you hear me?
now, can you hear me? That's the question.
Yes.
Can you hear me? And okay, so what I
Yes.
state, the court does have your copy of your motion to set aside the default. However, your recipe was incorrect and it is not on the docket at this time. You need to call the court, my law clerk, and determine what you need to do to correct that. Do you have the courtroom's phone number?
Yes, ma'am.
You need to call and speak with Taylor because apparently there's something wrong with your recipe. So,
Okay.
Ms. Clifton, how are we gonna receive? We don't have a date. We just put it in the system. Okay, so do you want to give us a date? Can we give it now? Do you want? Yeah. We're gonna give you another date and it will not be a Friday. So, Ms.
Your Honor, can I ask you one question? Can I speak and tell you something?
If it's factual, no, we're not dealing with the facts today. This is all
Okay.
procedural. This is all
Okay.
procedural.
Okay.
So what Ms. Clifton's, do you have her email address, Ms. Clifton?
Also, she's not sending me anything. She only sent me something because she sent me back what I filed in down at the courtroom. She's trying to send me stuff after the date, so I will try to look that up. She's sending me stuff like it was a hearing that had just passed. And
Okay, so don't worry about that. Don't worry about that. Don't worry about that. What we're gonna do is once you just call the court and then Taylor will assist you, and then Ms. Park, you'll have the date, of course, through e-filing. So this is going to be continued. I can't say what date it's going to be because you have to talk with Taylor first and ensure you get your documentation right. And then the press will go out. Ms. Park, she's going to know the date because she's on the e-filing system. So Ms. Park, you can present your
I did e-file though.
Hold on one second. Ms. Park, you're gonna submit your order as the court entered to today and indicate that the default judgment relative to Ms. Rumley will be decided at a different date. Ms. Rumley, you need to call Taylor and work it out. She'll get you a date. Thank you all.
Thank you.
You're welcome.
Thank you.
Nice meeting you, Your Honor.
Same here. Bye now.
Bye-bye.
Yeah, I guess we gotta hold on to this. Okay. I just said date to be determined. What number? I know you hate that we did that first. I know you hate we did that first. Okay, 2201. Morning, council. Ms. Clifton.
Harley Jacqueline et al. Versus Progressive Michigan Insurance et al. 2201465 NI.
Council appearances for the record.
Good morning, Your Honor. Matthew Grove for the plaintiffs.
Good morning, Your Honor. David Walls on behalf of Defendant Farm Bureau.
Okay. Was Progressive served?
Yes.
So is Progressive in this or what? Tell me.
I don't believe there was any response or anything. This is plaintiff's default motion.
Only as to the Asia Janae Milton.
Yeah, just to the third party.
Okay, all right. State for the record, when the complaint was served, the default was served as well as the notice of default judgment.
Yes, thank you. Defendant Milton was served with summons and complaint on February 21st, 2023, and has since failed to answer. Default request and entry were filed with the court on June 16th, 2023.
And served on her when?
Oh, I'm sorry. That was on 6/16/23.
Okay, and the notice of the default judgment.
Notice was signed. Sorry, I thought I had it right there. July 10th, 2023.
Okay. Give me a little bit of background before we proceed with any proofs.
Yeah, this was a motor vehicle accident that occurred on December 9th, 2021, in which plaintiffs Carly Jacqueline and Stephen Hooper sustained severe injuries. Objective testing is found.
Okay, you skipped over. What happened? Tell me the facts of the case. What happened?
I can let the plaintiffs describe the accident for you if you wish.
And would you raise your right hand? Do you solemnly swear or affirm to tell the truth, whole truth, and nothing but the truth?
Yes,
Mr. Grove,
Thank you. Jacqueline, were you involved in a motor vehicle accident on December 9th, 2021?
yes.
Can you briefly describe the court what happened in that accident?
I was driving on a street called Connor Street. And it's kind of like a T, so this, and then there's a street that goes like this, which makes like a T. And I was going through a green light, and the vehicle going on like the T part, T-boned me running a red light,
what side of the vehicle was hit?
the driver's side.
Go ahead. What happened next?
And then after the car was hit, it's like spun a little bit and hit the curb. And then I moved the car onto a side street. I couldn't drive it anymore. And then that car that hit me pulled over, and then they took off.
Okay, was your vehicle totaled or?
Yes.
And what happened after the vehicle took off? Did you call the police?
Yeah, I took a picture of their plate, and then I called the police and waited for the police.
Okay, what happened once the police got there?
They asked me what happened. They took a report and they told me that they were going to call a tow, but if my tow got there before theirs, that I could use mine. And then my tow showed up first. So I got towed to Steven's uncle's house.
Okay, you said Stephen's uncle's house. Who is Stephen?
The person that was in the vehicle with me, my fiance.
Okay, so whose vehicle was it?
It was my vehicle.
Okay. And what happened? How did you get to Stephen's uncle's house?
His uncle was only a couple streets away from where we were at, so he picked us up and drove us back to his house.
Okay, so what happened after you got to Stephen's uncle's house?
My daughters were in the back seat, so I was just monitoring them, making sure that they were okay. And then I believe I called and made an insurance claim.
Okay, then what did you do after that?
Stayed there for a while until we got a ride back to my house.
Okay. Then what happened?
And the following morning, I started noticing the pain a little bit more. So I called, I believe, my insurance company, and and then I called the attorney's office, and I don't remember who referred me, but I got referred to a chiropractor, and then I started seeing the chiropractor.
Okay, so how long did you see the chiropractor?
I'm still currently seeing the chiropractor.
How often do you see the chiropractor?
3 times a week.
Okay, and what does the chiropractor do when you see the chiropractor?
I go on a table and I get adjusted, like the automatic table, and then he adjusts me himself after I go on the tables.
Okay, who else are you seeing other than the chiropractor?
I have gone to different things, but none of them were long term, so mainly just a chiropractor.
Okay, so did you at any time go to the emergency room?
No.
Do you have a primary care doctor?
Not currently, no.
Okay. So other than the chiropractor, what other type of things? You said you did some other things that didn't work. What else was that?
I started a little bit of pain management. They prescribed a pain cream and some patches, but they didn't seem to help too much. So I just opted out of that.
How soon after the accident did you do that?
Real shortly after.
And how long did you deal with the pain management doctor?
I believe I only went like 3 times, and it just wasn't. The chiropractor worked better for me than the pain management.
Okay. Are you employed?
No, I'm on disability.
Okay. When were you placed on disability?
I believe like 5 years ago.
Okay. What was the basis of you being placed on disability?
I believe it's for fatal alcohol syndrome and anxiety.
Okay. So have you, how old are you now?
24.
Okay. So, did you graduate from high school?
No, I didn't.
Okay. And were you placed on disability before you graduated? Well, what grade did you complete in high school?
My last was 11th grade.
Okay, so after the 11th grade, was that when you were put on disability?
I believe so, yes.
Okay. So because of your disability, you never really held a job, correct?
Correct, yes.
All right. Mr. Gross, is there anything else you need to add?
Yes, if you could just briefly describe how this accident has affected your life.
I have 2 daughters, and it's made it very difficult for me to be a mom. And just do simple outdoor tasks, like I like to garden, and it's restricted me from doing that. But mainly being a mom, it's made it very hard to do the things that I used to do with them.
And can you describe your injuries?
Neck pain, back pain, tingling and numbness down my hands and legs. And I get severe migraines every once in a while.
All right. All right. Thank you. I don't have any further questions unless the court has any further questions. We would ask that the court grant our motion for default judgment.
Um, Ms. Jacqueline, what are the ages of your children?
5 and 2.
5 and 2. So when was the 2-year-old born?
She's August 17th of
Of
2020.
2020?
Yes.
Okay. Did you receive any x-rays?
When? After the accident?
Yes, yes.
Yeah, I believe I got MRIs and x-rays done.
Okay, so did they tell you anything after that you need to do anything special after you had the MRI or CAT scans done? I'm sorry, MRI or x-rays done.
Just to take it easy, because I could throw my discs off more if I do too much.
Okay, so when did you have the MRI and x-rays done?
I don't know the exact time, but it was really shortly after the accident.
Okay. Did you ever have any additional MRIs or x-rays done?
I had a few throughout the course of this time, but nothing within the past like 4 or 5 months, I'd say.
Okay, who performed your MRIs?
Michigan Diagnostics Center, I believe.
Who referred you to the MRIs?
My chiropractor.
Okay, and you said x-rays too?
I'm not positive, but I'm pretty sure, yes.
And that chiropractor would have referred?
My chiropractor, I think, did some x-rays.
Okay. So you said you had back pain. Tell me what you said you had back pain, neck pain, and what pain?
Neck, back pain, and I get tingling and numbness down my arms and legs, and migraines.
So you said you never had a medical doctor to substantiate anything?
What is that? What do you?
Did a medical doctor never told you what was wrong with you?
Chicken Diagnostic Center, and then I had seen another doctor, which was the doctor that was doing the pain management. And he told me what was wrong, but I didn't continue with the pain management because it didn't seem to be helping too much.
Okay, so you indicated to Mr. Grove that it was difficult for you to be a mom, but I need you to tell me specifically what you mean it was difficult for you to be a mom.
Well, like certain activities that like we used to go for walks every night, like I can't do that anymore because it affects my back affects that. We used to go to the trampoline parks every Friday. I can't jump on the trampolines anymore. So that's restricted. Just I have to take it more easy than I used to. Or like when they're playing outside, I'm more so sitting in a chair than able to play with them.
And I know, Mr. Walsh, you really don't have anything to do with this, right? You're just observing, right?
Judge, I just want to make a record of
Go
one
ahead.
thing. Your Honor, the motion and the testimony provided outlines a bunch of injuries that the plaintiff sustained. I would just add that under the case of Allstate Insurance Company versus Hayes, and the citation is 499 NW 2D 743 in the year 1993. That case states that a default operates only as an admission of liability against the party who defaulted. It does not bind a co-defendant who appears and contests the litigation. So if Your Honor is inclined to enter a default judgment against the third-party defendants, I would just ask that the court also consider Allstate versus Hayes as to defendant Farm Bureau's contesting the injuries as outlined.
Okay. And the situation here is that the defendant has not come forward, the defendant has not been in a position to litigate this matter, and the defendant is the only one who could, and because the defendant failed to and has not come forward to refute anything that the plaintiff has asserted, the court is inclined to grant a default judgment, but only as to the defendant, Deasia, Janine, and Milton, and the court does take judicial notice of Allstate versus Hayes, and of course, it does not relate to Farm Bureau as a party. Farm Bureau, I don't know if it's Farm Bureau Mutual and Farm Bureau General, Mr. Walker.
Yeah, to be honest, I represent both of them. They're the same company. I'm not sure why both are named, but I'm here for Farm Bureau
Okay.
as named in the complaint.
Okay, and the court notes that this does not have any effect bearing whatsoever on the position that Farm Bureau would take in this case. That being said, because defendant has failed to appear and failed to litigate this matter in any way, shape, form, or fashion, the court will grant a default judgment in the amount of $15,000. Mr. Groves, you can present the paperwork to the court. And again, this default is only as to Ms. Milton, and it has no bearing whatsoever on the case as it relates to the Farm Bureau parties.
Thank you, Your Honor. I believe Stephen is here to testify as well. I think our motion was for both Stephen and Carly.
Do we have Stephen?
Is Stephen with you, Carly?
Yeah.
Judge, if I may, as it relates to the second plaintiff, I just make the same argument.
That's
Okay,
fine.
thank you. And the court takes notice that Mr. Watts indicates that relative to Stephen Hooper, that the case of Allstate versus Hayes controlled from this matter. Ms. Hooper, would you raise your right hand? Do you solemnly swear or affirm to tell the truth, whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. Mr. Grove?
You, Mr. Trooper, were you involved in a motor vehicle accident with Carly Jacqueline on December 9th, 2021?
Yes.
And were you injured in that accident?
Yes.
Can you please tell me of your injuries?
My neck a little bit, my back mostly, and my feet tingle all the time.
And did you receive medical treatment?
Yes.
Can you tell me about the medical treatment you got?
It was mostly the chiropractor and the pain management doctor, like 3 different times.
And how long have you been training with the chiropractor?
From like the beginning of that, from when the accident happened to present day.
And how have your injuries affected your ability to live your daily life?
Well, before the accident, I was a roofer, and I wasn't able to work after.
How long have you not been? Have you since been able to return to work?
Yeah.
All right. How long were you off work for?
Since the accident.
Okay. Have you returned at all to work after the accident? Okay. Is there any other ways this accident has affected you?
Well, it affected mostly my work schedule because I work quite a bit, but Yeah, I'm just at home now, just not really doing nothing.
I don't have any other questions for you, and the court might have some questions.
Okay.
Mr. Hooper, did you ever go to the emergency room?
No, we went home with our kids that night.
Do you have a primary care doctor?
I did, but not anymore.
Did you receive any MRIs?
Yes.
How many?
I think 2.
And were they close to the time of the accident?
Yes.
Did you receive any x-ray?
Yes.
And how many?
I know one for sure that was at my chiropractor's office, but I don't know exactly if I had any more after that.
Okay, and you said you were a roofer. When was the last time you worked prior to this accident?
Probably like not too long before the accident, like a week before,
Okay,
because it was winter time and work was slow during the winter.
okay, so on an annual basis, approximately how much do you make a year?
I never really added it up.
Do you pay taxes? Or you
What?
get paid under the table? Do you pay taxes or do you
Under
get
the table.
And you said that primarily this affected your ability to go to work?
Yes.
And Mr. Watts, other than what you previously articulated relative to Allstate versus Hayes, you have nothing else to add at this time, correct?
That is correct, Your Honor.
Okay. Based on the fact that Ms. Milton or no one on her behalf has come forward, the court to litigate this matter, the court will enter a default judgment against Ms. Milton and as to Mr. Hooper in the amount of $22,000.
Thank you, Your Honor. I will submit an order.
Thank you. And we'll see you all soon on the balance of this case.
All right. Thank you.
Thank you, Judge.
Thank you very much.
You're all set. You're all set, Stephen.
Okay, this is a bit much to get started. Okay. Okay, they're here. Okay. When you're ready, Ms. Clinton.
This is CrestNet Lease Incorporated versus Boston Market 2300367
Morning, council appearance for the record.
Good morning, Your Honor. Mitchell Cap on behalf of Crest Inc.
Mr. Cap, since this is a case involving two entities, the court has to reassign it to business court. So you'll get notice on the through the e-filing system when it's been reassigned, but the court is going to reassign this to the business court.
Okay,
Okay,
very
thank
good.
you. Thank you.
Thank you, Judge. Have a good day.
Good morning.
Good morning.
Okay. Ms. Clifton.
Diversified Members Credit Union versus James Davis, 23001-757 PD.
Council Prince for the record.
Yes, good morning, Your Honor. Stephen DeLuca on behalf of the plaintiff's Diversified Members Credit Union.
Okay, and this is your motion for entry of default judgment, correct?
Yes,
Okay, and can you articulate for the record when the complaint was served, when the default was served, as well as the notice of default judgment?
yes. This defendant was served under an order for alternative service. He was served by first-class mail and by certified mail on April 25th, 2023. He was also served by tacking at his last known address on May 17th, 2023. A default was properly entered against the defendant on June 23rd, 2023, and a copy of the default entry was first class mailed to the defendant on the same date, on
Okay,
June 23.
and that's when he received notice of this hearing as well?
He received notice of this hearing not until July 14th, 2023.
Okay, and this is default judgment for possession and monetary relief, correct?
Correct.
Okay, and the base of this is the Harley Davidson 2021 Harley Davidson.
Yes.
Okay, and the court notes that there's an affidavit attached of Patricia Schronek supporting the money damages in this case, correct?
Correct.
Okay, so tell me what is the financial relief that you're seeking at this time?
We are seeking a money judgment for damages the way these judgment forms are, let me restate that. So, damages $28,613.90. Court costs $319.16. A statutory attorney fee is $75. We've received payments or credits since filing this action in the amount of $3,058.02. So the total judgment amount that we're seeking is $25,950.04 plus statutory interest that's accrued since the time we filed the complaint.
Okay. So based on the representation placed on the record, the court is satisfied. The court will enter default judgment in the amount of $25,950.04 based on the representations placed on the record. You can present the judgment to the court for entry and we'll sign it.
Thank you, Your Honor. And just for me to clarify, in addition to the money judgment, since this is a claim and delivery action, we are also seeking possession of the subject vehicle. Okay.
So noted. So the court will grant the default judgment in terms of possession as well as the money judgment. And we'll look.
Thank you, Your Honor.
To file. Thank you.
We'll submit it today. Have a good day.
Thank you as well.
All right.
And Cooking call.
The estate of William Douglas et al. Versus Isis Smith, 23001-726 CH.
Council appearance for the record. You're muted. You're muted.
Good morning, Your Honor. Ronald Bajorek. I'm the attorney for the plaintiffs, estate of Smith and Ms. Luvone Appling Smith. My client is here with me at my office.
Okay, and this is your motion for entry of default judgment, correct?
Yes, the defendants are actually the daughters of the decedent and one of the daughters of my client. The decedent back in
Okay,
2000.
first, before you go there, please state for the record when the complaint was served, when the notice of default was served, as well as the default judgment was served on the defendant.
Yes, the defendants were served on, Ms. Arnold was served on February 21st, 2023. And the other defendant, Isis Smith, was served February 23rd, 2023. Both of those, I filed proofs of service, which I have copies. They're attached as Exhibit 3, which were filed June 6th, 2023. And then the default entries were entered on June 6th, 2023 for both defendants. And the proof of service for the default entries were served on the defendants on May 24th, 2023. And those proof of services are on file with the court. I also served them with today's motion and notice of hearing, which proof of service I filed for today's hearing also. It's our information that the defendants are not either contesting or don't intend to respond.
Okay, so now you can give me a little bit of the factual background, please.
Yes, thank you, Your Honor. My client lives at 291 East Boston in Detroit. Her and her husband had that home for 28 years. She was married to the decedent William Douglas Smith for 41 years when the decedent died back on, I'm sorry,
May 26th.
May 26th,
2022.
2022. My client found that for some reason, her husband had recorded a quitclaim deed, which is attached as Exhibit 4, which in which it purports that he was conveying the marital home to the two daughters, which are the defendants. And under Michigan law, this home was owned by the parties as tenants by the entirety, husband and wife. My client never consented to her husband quitclaiming the home to the daughters, and by law, he had no right and no legal ability to convey his interest in the marital home without my client joining in that conveyance. So what we're asking the court to do is issue a declaratory judgment that the real estate at 291 East Boston, Detroit, Michigan, indeed is and was still owned by my client, and that the two daughters, the defendants, have no legal rights to that property, and that the daughters' heirs don't have any legal rights to the property. We would also like the order to be in recordable form, and I prepared a proposed order that I can email or e-file.
Yeah, hopefully he'll come back. He's almost finished. Will he come back in, or do you have to watch for him? Mr. Bajork, are you still with us? It's Kim, it says it's muted. Okay, there you go. Mr. Bajork, are you still with us? Mr. Bajork?
Can you hear me?
Yes, now I can. Yes, yes, yes. We're almost at the finish line. And I guess
Yeah,
just
I apologize. My laptop battery gave out. It only has limited life, but basically what I'm requesting that the court do is just to sign an order of declaratory judgment that my client is the owner of the property and that the deed that the decedent signed back in October 14, 2005 is of no legal effect, and that the defendants don't have any survivorship rights or any rights to that property. And the order will also finalize and close the case.
okay. All right. So based on the representation placed on the record, the court finds that Ms. Luan Appling Smith is the sole owner of the property located at, give me 1 second, 291 East Boston, and that her daughters had no legal rights to the property, nor do any of their heirs or assign, and that the quitclaim deed that was executed and entered on, I think it was October the
14th.
October 14th. Wait, let me see.
It's signed on October 12, 2005, recorded on October 14th, 2005.
That was recorded on October 14th, 2005, has no legal merit and should be disregarded, and that this should be presented in a form of a recordable instrument indicating that Ms. Smith is the sole owner of this property, as the fact that she and her husband owned that property while he was still alive at tenants to get in. I think it was tenants by the entirety, wasn't it?
Yes, Your Honor.
Okay, that he could not prepare another deeding away his interest in the property without having his wife deed her interest as well. So, Mr. Bajork, I will look for the order to be submitted to the court by e-filing.
I will get that done within the hour. Thank you.
Thank you very much. Have a good day.
You too. Bye-bye.
Bye-bye.
This is 2300345 Fremont Insurance Company versus Devin Floyd.
Council Pence for the record. You're muted. You're muted, Ms. Lewis.
Asia Lewis for the plaintiff, Fremont Insurance Company.
Okay, this is your motion to appoint. Empire, give me a little bit of background.
Yes, Your Honor. So we were opted to go through the appraisal process via the policy agreement. And we both chose appraisers and they weren't able to come up with an amount for the damages. So at this point, we're asking you to appoint an umpire. And as far as I know, we haven't had any contact with Mr. Floyd since choosing the appraisers and finding out that they weren't able to agree upon an umpire themselves. So today we're asking for an umpire to be appointed. And there's been no contact since, I believe, March.
With Mr. Floyd?
Yes, with Mr. Floyd or any counsel. I believe we had one phone call back in March from someone who said they were representing him. And as far as I know, no appearance or anything was filed after that. We were going to try to get the case resolved. We heard nothing back from anyone.
Okay, now who has the property?
Excuse me?
Who has the property? Is he in to his property? So is he still insured by?
Is he still insured?
Yeah, tell me, I'm confused here. So he's the defendant.
Mm-hmm. So we've already filed a motion prior to go to make sure that we adhere to the appraisal process via the via the policy, Fremont's insurance policy, which requires us to go through the appraisal process. So we both picked, I believe Floyd picked David Shipper as an appraiser, and we picked Mark Kamaj as an appraiser, but both of them were unable to agree upon selection of an umpire. And this was back in March of 23.
Okay, so the court will appoint an umpire, but I need the appraisers to each submit to the court 2 names, and then the court will select, and they need to do that within 7 days.
Okay. And I believe it was my understanding that Mr. Floyd does have counsel now, or are we?
Oh, is this Mr. Floyd? Who's your counsel now?
Steve Robinson, Your Honor.
Okay, can you place your, I'm sorry, could you place your appearance on the record, Mr. Floyd?
Devin
Just
Allen
state your name.
Floyd.
Thank you. Okay, so what the court is you need to make sure that your counsel files an appearance and that he contacts Ms. Lewis. And additionally, as I indicated, I don't know if you heard me, what needs to happen is both appraisers need to submit 2 names to the court within 7 days. And Ms. Lewis, you can file this order and then supplement, get the court in order with those names in it.
Okay, absolutely.
Okay, so they have 7 days to submit the names for 2, and the court will select an umpire from those names submitted.
Okay.
Okay, and like I said, Mr. Floyd, please ensure that your counsel files an appearance and that he contacts Ms. Lewis, and that he gets Ms. Lewis those 2 names within 7 days so she can present them to the court in the court. So Ms. Lewis, just put the 4 names in it and then leave a blank for it, and the court will select one of the 4 and will put the order back to the parties.
Okay, so Your Honor, I'll just submit the first order just indicating about the 7 days and having the names, and wait on Mr. Floyd's counsel to contact me with his, and then submit another,
Order with all 4 names, and then the court will select one.
Okay, thank you, Your Honor.
All right, thanks. So Mr. Floyd, please ensure that you have your counsel reach out.
Your Honor, may I make a statement?
Sure, briefly.
My attorney has been working with Michael T. Ryan in order to find an umpire to agree upon. And
But no, we're not doing that now. What we're doing is, as I indicated, your counsel can submit 2 names, and then foremost, Fremont, I'm sorry, can submit 2 names, and then the court will select.
Yes, ma'am.
Okay, thank you both.
Thank you. Have a great day, everyone.
You as well. What number?
Virginia Mixner et al. Versus Amanda Yukis et al. This is case number 230000605NI.
Council appearance for the record.
Well, Your Honor, Kimberly Curtis, on behalf of the defendants, Amanda Yukos, and Earl Woods.
Okay, Ms. Curtis, this is your motion to compel the initial disclosures, correct?
That's correct.
So we'll give the plaintiff 7 days, so you can prepare an order indicating plaintiff must present their initial disclosure within 7 days.
Thank you, Your Honor. I'll put that over.
Thank you very much. Okay.
This is Diane Hancock et al. Versus Lifeline Concord et al. 220100607NO.
Council appearances for the record.
Good morning, Your Honor. Melissa Filipovich appearing on behalf of the plaintiff, Diane Hancock, as personal representative for the estate of Daisy Bramwell, deceased.
And good morning, Your Honor. Reno Airball on behalf of defendants.
Okay, and this is the defendant's motion, correct?
That is correct, Your Honor.
Okay, so what's going on procedural that we need more time at this point in time?
Your Honor, as detailed in the motion to adjourn, there has been issues with the probate hearings and the underlying plaintiff. We need to get a guardian that was denied, and honestly, Melissa, you might be able to better provide the history on that because you've been covering this case. I'm just kind of covering it for Caitlin, if you don't mind.
Yes, Your Honor, if I may.
Yeah.
So we had, unfortunately, there was a conservator that was established or set up for the husband of Miss Daisy Bramwell. And because he's first in priority technically in probate proceedings, when the conservator became the conservator through the probate court, they then filed a petition to remove Diane Hancock, even though the husband had, at the time that he was competent, agreed to Miss Hancock being the personal representative. The probate hearings got delayed because there was some issue with service as well. And then the attorney had not showed up that had represented the estate. So until about, I believe it was either the end of March or beginning of April, we weren't entirely sure who would be the personal representative, whether the judge would remove them. So then we got discovery going and we set up various depositions. There was a request, and I think that there was a misunderstanding between myself and counsel. They had requested one of the children, who is Bridget Bramwell, her deposition, but she was shot in the head, and she also has a conservator, and that conservator was actually they were in the process, but she was just legally established as the conservator, and she is not competent to testify. I mean, she's not the standard 25-year-old girl, and it was very evident in the deposition as we went through it. So Ms. Zolna and I, who is the attorney that has been working on this matter, we agreed to recall Bridget if necessary, but we're moving forward with scheduling, and our office is certainly helping to reschedule the deposition of Colleen Dumas, who's the conservator for Bridget Bramwell. And then in addition, we have been working on getting dates and deposition dates available for defendants and certain corporate representatives. That's something that we've talked about. And we've also hit a little bit of a snare in getting certain records from the villas based on what came out through some testimony as far as how often the family had visited and certain visitors logs and stuff like that. We've been diligently prosecuting the case. It just kind of got delayed on being able to move forward because we didn't want to provide answers to interrogatories that perhaps the new attorney and new conservator, which would have been Mr. Sakis, Robert Sakis, I believe it is, his office was going to take over the case if this new conservator had gotten appointed.
Okay, so who is it? Is it Diane? Is Diane the personal rep?
Yes, the judge agreed that she should be the appropriate personal representative. She's the one that has all the knowledge regarding medical records, treatment, access to all the records and stuff like that, which made sense to move forward and advance the case.
Okay, well, like I said, I know we're on track 2, and I just was concerned why we're going to track 3. So the court, I'll give you track 3. Your witness list should have already been filed, were they not? Or tell me what you're.
They have been, Your Honor. So I believe we did actually file witness lists, and I think that we might have even filed amended ones as well, if I remember correctly. One of the other issues, though, too, which is why there's been a little bit of a delay. If you recall on the docket, the defendants have filed a notice of non-party at fault for a products liability issue. So it has been a little bit difficult getting our experts and getting everything set up to inspect the vehicle as well, in case it's a almost $10,000 expense that both parties would like to preserve for each of their clients, myself included and the defense included, if we get certain records from Braunability to determine first if that's even necessary in the first place. So that is one also significant factor that's kind of delayed us in determining whether or not Braunability does have any liability in this for a products issue.
Okay, that's why I asked to see what's going on. Give me 1 second. Okay, what I'm going to do is, and like I said, I don't expect you guys to come back. What I'm going to do is I'll give you Casey Val in December with discovery through Casey Val. That's why I wanted to know what's going on, and I understand, so that's why otherwise discovery will be up in October, but I want you all to ensure that you have ample time. So Casey Val in December with discovery through Casey Val. And I'm not going to say no further adjournments because I'm hopeful that you'll get this done. But I understand the complexities here, but please note that I'm not inclined to grant any more adjournment. Okay.
Your Honor.
So I'll look for the order to be submitted to the court.
Thanks, Ryan. I can draft it.
Thank you both.
Very much appreciated, Your Honor. Thank you.
Have a good weekend.
Welcome. Take care.
Thank you, counsel. Have a good day, everyone.
You as well. So for this stuff, but they got 2 claims, so we got to take testimony. Yeah, it's gonna take a minute. Counsel, we're gonna place you back in the waiting room for a minute, because I know this is gonna take time. Do you have both of your both plaintiffs here?
Judge, unfortunately, Mr. Martin couldn't get on Zoom and won't be able to be here today. I'd like to go forward with the least Miss Love Guy's motion so we can get her done if that's okay.
All right. Okay, Ms. Clinton. Making it simple. So what are we gonna do? Just adjourn, do hers? You're gonna submit an order and indicate it's continued to whatever date we give you?
I'm happy to do that, or just see if he's even wanting to go forward with this anymore.
Okay, well, we'll give you another date, and then, you can do what you need to in the interim.
Thank you.
Think about a date once I call the case, you call the case. Go ahead.
Jocelyn Love Guy et al. Versus Eric Payne et al. 22008-272 NI.
Counsel appearances for the record.
Good morning, Your Honor. Paul Wheatley on behalf of plaintiff Jocelyn Love Guy.
Morning, Your Honor. Michael Root on behalf of Defendant Farm Bureau.
And Mr. Whitley, give me a little bit of background, then I'll avoid swearing, you can avoid here.
Thank you, Judge. Ms. Loveguy is here. She was a plaintiff in a crash from July 14th, 2021. This is a case for no fault PIP benefits and a bodily injury claim. Unfortunately, the negligent driver, Mr. Payne, has been defaulted. Those defaults were entered with the court. Mr. Payne was also notified of this hearing by certified mail in June of this year. It's around 11 o'clock or almost noon, and I haven't heard from him, or I don't see him. Miss Loveguy's injury, she was only 29 at the time of the crash. This is a large crash, as you can see by Exhibit 4. She had a loss of consciousness in the crash, a pulmonary contusion, collapsed lung, fractured ribs, a hematoma that required surgery, like a surgical pump insertion, continued headaches, neck and back pain. She was administered nerve blocks and trigger points, injections. She's making a good recovery now, but this is a large crash with catastrophic injuries for a young lady.
Okay, Mr. Root, you represent Progressive.
Defendant Farm Bureau. We don't necessarily have a particular dog in this fight today. We're just here to report to the client.
Okay, now Farm Bureau, is Farm Bureau the PIP provider?
Yes, for Mr. Martin.
Oh, okay, so Mr. Martin had insurance, right? Or you're the assigned claim?
Correct.
Okay, so what's Progressive's?
Progressive would be the PIP carrier for Jocelyn.
Okay. So, all right, so but they're not here.
I don't know if they have any dog in
Okay.
the show today.
Okay, all right, so
right.
Mr. Root would just be interested in knowing the new date for, okay. Miss Loveguy, would you raise your right hand, please? Do you solemnly swear or affirm to tell the truth, whole truth, and nothing but the truth? You're muted, ma'am.
Yes.
Thank you. Mr. Wheatley.
Good morning, Ms. Loveguy. Can you please introduce yourself to the court?
I'm Jocelyn Loveguy.
Ms. Loveguy, we filed a motion today for a default judgment of Mr. Payne, who was the negligent driver in your crash. You understand that we're here today asking the court for damages in your case that you would then try to take to a collections attorney to collect on those damages from Mr. Payne. Are you aware of that?
Yes.
We are requesting today on your behalf $1.25 million in damages from Mr. Payne's negligence. Are you aware of that?
Yes.
You agree that as a result of this crash, you suffered loss of consciousness, fractured ribs, concussion, among other injuries?
Yes.
Did you undergo injections as a result of the crash?
Yes.
Did you undergo a surgical pump insertion for your hematoma?
Yes.
Are you pleased with the representation by our law firm through today?
Yes, I am.
And do you have any dispute as to us requesting the monetary amount on behalf of you for against defendant Payne?
No.
Judge, I have no further questions unless you need anything.
Okay, Miss Loveguy, how long were you hospitalized after the accident?
Yes, I was. I stayed for a day.
For a day?
Then I went back on my own.
Okay, were you transported to the hospital by EMS or did you go on your own accord?
EMS.
Okay, and you said they kept you in the hospital for a day? Okay, and after that happened, what happened after you were released from hospital?
I was still in a lot of pain, so I went to another hospital. I went to Providence in Southfield.
Okay, what happened at Providence?
They basically did what St. Night Grace did, but they made sure I wasn't in pain, and they made sure they sent me home with actual medicine so I can, get through my day.
Okay, so did at either Providence or Sinai, did they perform any x-rays?
Yes, both did.
Okay, did they perform an MRI?
I don't think it was MRI. I think I got CAT scans at both
Okay.
hospitals.
CAT scan. Okay, after you received the CAT scans and the x-rays, did you have an occasion to seek treatment from another doctor?
There I went to my own doctor, and then I was referred to Prodigy, which is a chiropractor, to help with my back. So I started treatment with them, and then they referred me to physical therapy. And Prodigy also referred me to a pain management doctor.
Okay, so out of the chiropractor, physical therapist, and the pain management doctor, are you still treating with any of those individuals?
Not at this time.
So how long did you treat with the chiropractor?
If I'm not mistaken, I'm not actually sure. I think it was like 3 or 4 months, maybe.
Okay. And how long with pain management?
The last time I seen the pain management doctor, I want to say it was early this year, like January of this year.
And what about physical therapy? How long did you do the physical therapy?
I think the script was only for like 6 or 8 weeks.
Okay. Were you employed before this accident?
Yes, I was.
And where were you employed?
It was called Great Lakes Rubber.
What did you do at Great Lakes Rubber?
I did what they call inspecting and trimming.
Okay, and how long were you at Great Lakes Rubber?
From, I think it's 7 years, from 2016 to last year, 2022. Or 6 years.
Okay, and why was it that you stopped at Great Lakes Rubber?
I decided to quit. I just felt, yeah.
So are you working at a different company now?
Yes, I do home health care now.
You do home health care?
Yes, ma'am.
Okay, and what are your tasks as a home health care provider?
I just make sure that their home is clean, that they're clean, that they're safe, they eat, take medications.
Are you at an institution or do you go into somebody's home?
Someone's home.
Okay, and how many days a week do you go into that home?
5 days.
Okay, what are the hours that you go into that home?
They vary because I have 3 different clients.
Okay.
So they vary.
Okay, so but each client, how many hours are you with them a day?
It's between 3 and 9 hours.
Okay. Okay. Did you receive any scars or bruising as a result of this accident?
Yes, I did. It's my left side where the hematoma was, where I had to have the procedures done.
What procedures did you have to have done?
I had a drain put in because it was huge and they just tried to get all the fluid off. So I had 3 procedures to drain the fluids.
Okay, and how long did it take for them to get all that fluid off of the hematoma?
Took quite a while. I think
couple months.
Yeah, it was a couple months.
Okay. And how long did it take for that hematoma to heal?
Well, after the drain was removed,
Yes,
took a few weeks for the scarring to heal up.
to start here, but I know it's not, but you still have a scar now, right?
Yes, ma'am.
Okay, but for it to scar over and it not cause you any pain, how long did that take?
Honestly, maybe like a month for everything just to go back to normal.
Okay, and how big is the hematoma now? The scarring?
It's like a little. It's like where it's like just like a little strip. I don't know how to explain that.
Okay, so is it on you said it's on your thigh?
No, it's on my left side.
Left side.
Yeah, like the side. Yes.
Okay, so is it underneath your arm or more to the back or more to the front?
Smart to the side. It's like my stomach on the side.
Okay.
Right above my waist.
Okay, so did it perfectly heal, or did it keloid, or is it
No,
flat?
it's smooth. It's smooth skin now.
Okay, all right. Other than that, what were the injuries that you sustained?
I believe my wrist was fractured. That healed properly.
Did you have a cast on your, or just a brace on your wrist?
Not my wrist, my ribs.
Oh, I'm sorry, your ribs. Okay,
Yes.
so did the x-ray show that your ribs were fractured?
Yes, ma'am.
Okay, and how many ribs were fractured?
I think it was 2, if I'm not mistaken.
And do you know how long it took for your ribs to heal?
I do not. I know it took quite a while for it to feel decent to breathe in.
Okay, so did they give you some sort of brace or something for your ribs?
No.
Okay. Did they tell you to limit your activities while your ribs were healing?
Yes, ma'am.
And what type of restrictions did they give you while your ribs were healing?
I think it was for my ribs and my back because they both were messed up.
So what did they tell you?
No heavy lift.
Go ahead, I'm sorry.
Like no heavy lifting. No, I actually don't remember exactly what was said, but I'm pretty sure it was the limit on what I can lift and the amount of activities I can do.
Okay. How long were you limited?
For my ribs, I don't know exactly how long, but my back, I think up until I stopped seeing Dr. Marshall. He had limitations.
Give me approximate time frame.
Maybe from the time of the accident up until, I don't know, maybe when I stopped working at GLR.
And when did you stop working there?
In November.
Of 22?
Yes, ma'am.
Okay, so how soon after the accident did you go back to work?
I went back to work. Think I went December, like a week, and then I had another procedure done, and then I went back officially in January.
Okay, so when you went back to work, did they still have limits on what you could do?
Yes, ma'am.
Okay, do you remember approximately how long they gave you limits when you went back to work?
I think, like I said, I think it was just for as long as I worked there. Because he never, I had appointments with him every few months. Or, yeah, every other month I had an appointment with him. And he just gave me the same order every time. The same orders. Take it easy and don't lift more than 10 pounds. Those were the things he was saying.
What was the date of this accident?
July 14, 21.
And you worked at Great Lakes until what part of in 22?
November.
In your job, did you have to do any lifting? Or was it just inspect? Because you said you were, you said you a trimmer and what else? An inspector? And a trimmer?
Inspector. Yes, there was some lifting. That's why it was a limit on what I could, how much I could lift.
Okay, but you were still able to do your job?
Yes, because I was just sitting down.
Okay.
It was a sit down job. It wasn't like really physical.
Okay. Okay. Based on the representations placed on the record, the court will enter a default judgment, and then the court will enter a default judgment in the amount of $75,000. Mr. Wheatley, you can prepare an order for the court to forward into the same.
Thank you, Your Honor.
It's more so in terms of the permanent serious disfigurement. The court didn't know that she had a serious impairment. And we know that the serious impairment does not have to be permanent, but that she did have some impairment for a certain period of time. So according to your judgment, amount of $75,000. And let me get you a date. Miss Clifton, can I have a date to return for the other part of it? August the 11th at 10:45, Mr. Wheaton, for Mr. Martin. August the 11th.
Very well.
At 10:45. Okay, and like I said, and you can determine whether or not, if he doesn't want to, just let Ms. Clifton know and she'll take it off the docket. Otherwise, I'll look for the order today relative to Ms. Loveguy.
Thank you, Your Honor.
Thank you. Thank you both. Thank you all.
Thank you.
Thank you.
You're welcome. Use the first show calls. What date can I use for show calls? Okay. Ms. Clifton.
This is Alondra Ochoa Rivera versus Deontay Townsend et al. 220041331NI.
Council print for the record, Mr.
Good afternoon, Your Honor. Michael Root on behalf of Hanover Citizens. I just want to make sure, Ms. Clifton, there's nobody in the waiting room, right?
He's checking.
Okay.
This Mr. Cruz Senior. Mr. Cruz Senior. Okay. All right. Can you state your name, sir? You're on mute first. Unmute yourself. Can you state your name, please?
Moises Cruz.
Okay. Mr. Cruz, what's your first language? You speak English, correct?
Yes.
Okay, great. Mr. Root, had you had an opportunity to talk to Mr. Cruz Senior?
Yes, so previously we spoke, and I know he talked to another one of the attorneys in my office. I was aware that he may be waiting in the waiting room. Mr. Cruz, I know that you and I had spoken before. We were trying to get your deposition to clarify some things. And I know that you are working, you're a busy man. I won't take much of your time. Is there a date over the next couple of weeks that maybe you can take about a half hour out of your day?
Okay, hold on a second. Hold on a second. Ms. Clifton is going to give all of you all an invitation to a breakout room. And then you can determine a date and then just come back in once you. Okay, Miss Clifton will come get you. She's going to give you an invitation to go to a breakout room. When you get that, click on that, and then she will check on you and bring you back in. So do not leave, but just stay there till Miss Clifton brings you back in. Okay, let's move on. I'm 13. Counsel? Ms. Clifton?
Afternoon, Your Honor.
This is case number 22011-862-NI, Murad et al. Versus Progressive Marathon et al.
Counsel appearances for the record.
Good afternoon, Bill Farr on behalf of the plaintiff.
Good afternoon, Brett Mellon for defendant Kristen Byers. They're my motions, Your Honor.
Morning, Your Honor. Cody Brock here representing the MAIPF on this one.
Okay, Mr. Mellon, what's going on procedurally with this case that you need more time?
Plaintiff has, frankly, Your Honor, and I don't mean to. We've noticed her up for depositions, IMEs. There's been multiple motions to compel. I have a motion to compel an IME. It was noticed. We just got a deposition date. It's not till September, so I have two motions up today, Your Honor.
Wait, let me make sure.
Okay.
That just has a form.
So I've.
Okay, so why
I
is
have a motion to compel.
why is it that we are not getting this step done until September?
It's been noticed and canceled multiple times by plaintiff, Your Honor. I just frankly, there's been new parties added. We need more time. We can't properly defend this case due to plaintiff's non-cooperation, really. There's been no responses filed to the motion except for
You break it up, Mr. Mellon.
I'm sorry. There's been no oppositions filed to either of my motions besides a concurrence from defendant State Farm. At this time, we'd ask that the court adjourn the scheduling order to track 3 and compel the IME of the plaintiff.
Okay, so you said there's been other motions to compel. So wait, you got the IME set. Do we have a date for this IME?
No, I can have it scheduled within 45 days with a date certain and file an order either today if I can get a date.
So what about this debt? The debt is for September what? This is just the end of July. Why, Mr. Farr, what's going on?
Your Honor, I apologize. This situation, this is a minor child, and he is a representative who's his father. Our office has had some communication issues with the father, just not being cooperative in the sense that, his son is trying to go forward, but the father's not being cooperative with our office. Well, he wasn't being cooperative, I should clarify. At this time, we've had a breakthrough with the father. We've had in-depth communication with the father and let him know that, you have to cooperate, you have to comply with these things. And we feel like at this point, he's understood that and is now willing to comply. And obviously, the son is, he's a minor, so he needs his father to take him and do these appointments for him. So that's just been the holdup on this one. But like I said, I think we're in a better place now in terms of responsiveness and understanding on our part from the plaintiff's perspective.
Well, hopefully you got some client control because this doesn't look good. So relative to the IME, Mr. Mellon, that's got to be done within 30 days.
Okay, I will get a date.
Give me 1 second. What's the date of this step? I want this step in order to Mr. Farr.
September 28th.
Oh my God, are you kidding me? That's not gonna work. Why September 28th? That's 60 days. No. Why are we talking September 28th?
Your Honor, I'm not exactly sure. I know this was just scheduled, so.
That's not gonna work. Nope, 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 nope. And see, the thing is, I'll say IME within 45 so you can get this DEP in within 30. So IME 45 days, and whatever magic you can work fine, but that DEP has to take place within 30 days, not 60 days.
Okay,
That's why
appreciate that, Your Honor. We'll get new dates.
That's why I ask these questions. Because that'll push this, you be, oh, Judge, I need more time. Plaintiff debt within 30 days. And Mr. Fried, you gotta get some client control.
Understood, Your Honor.
And I'll give you Casey Val in October with discovery through Casey Val. Thank you, Judge, for giving us more time.
Thank you, Judge, for
I
giving us
appreciate
more
it.
time.
Thank you, and I'll look for the order to be submitted. Have a good weekend, gentlemen.
You as well.
Your
Thanks,
Honor.
Judge.
Thank
I'll
you.
look for the orders. Bye now.
Thanks.
Okay, everyone, you need to unmute yourself. We're back on Ocho Rivera. So, Mr. Root, do you have a date now for Mr. Cruz Senior's deposition?
Yes, August 11th at 10 a.m.
August 11th at 10 a.m. for DEP. And we're still gonna have a show cause day. Ms. Clifton, since they're doing August 11th, what day we're gonna use for the show cause? August 25 at 10 for the show cause. In the event that it doesn't go, Mr. Cruz, if you're done August 11th, you don't have to worry about August 25th at 10. So hopefully just get it done so you don't have to come back on August 25th. Give me 1 second. Okay, so Mr. Cruz Senior, you have your date, right? You're on mute, sir. That's all right. Just shake your head yes, so I know you understand. Okay, fine, you're fine. Mr. Cruz Senior, you're free to go, and you're gonna deal with this and be available for your DEP on August the 11th at 10, correct?
That's correct.
Okay, all right. Thank you very much. You're free to go, sir.
Thank you. Thank you all.
Okay.
Thank you, Mr. Cruz.
Yeah, now what about as to Cruz Jr.?
So, Mr. Cruz Jr. has voluntarily denied, or he's opted not to cooperate. We've spoken with him a couple times, and he's not going to show up for any depositions. He doesn't want to deal with any subpoenas. I can give you just a quick backstory. So these are MACP cases. Motor vehicles weren't identified on the applications for benefits. There are 2 motor vehicle accidents in April of 2021. There have been several adjournments due to consolidating the cases. Plaintiff wanted to add some parties. We finally took plaintiff's deposition back in April, and motor vehicles were identified. So now we're just trying to confirm or deny maybe a higher priority insurer. We scheduled the the depositions of Moses Cruz Jr. and Sr. So that's plaintiff's ex-husband and father-in-law for June. I spoke with both of them. They both said they weren't going to show up, hence why we're here today. It sounds like Mr. Cruz Sr. is cooperating now, but not so much as Mr. Cruz Jr.
Okay, so Cruz Jr. is the ex-husband of the plaintiff. So, and I'm just asking for my own edification. Were they still married at the time of this accident?
Yes.
Okay, all right. So, because I think what you need to impress upon Mr. Cruz Jr. is that if he doesn't comply there's going to be a bench warrant. So, at this point in time, we'll give you 21 days, 21 days to schedule the dep. Schedule and take Mr. Cruz Jr.'s dep to take. And if he fails to appear, then we'll have a show cause on August 25th. What time did I send Clifton? At 10 o'clock. And if he fails to appear and we have to go through the show cause, indicate there's going to be a bench warrant.
Okay.
Okay.
So for the order, you want me to put that he must appear for his deposition within 21 days?
Yes, yes,
Okay.
yes. And you schedule the date, and if he fails to appear, show cause will be set for 8:25 at 10 o'clock. And at that time, if he has not appeared, there will be a bench warrant issued.
Okay, excellent.
Okay.
Okay.
All right. Thank you very much.
Thank you, Your Honor.
Thank you, Judge.
Have a good one.
You too.
Okay. 14. Okay. I need a pen. Okay.
This is David Johnson versus Darren Smith et al. 230014449 NI.
Good afternoon, Judge. This is Ryan Ford on behalf of the plaintiff and the petitioner in this matter, Christopher Train and Associates.
Good afternoon, Your Honor. Jessica Mills on behalf of defendant State Farm.
Okay, Mr. Ford.
Yeah, no, this is our motion to withdraw. And as you read in my pleadings, Mr. Johnson has, in my opinion, effectively abandoned his case. He has not responded to any of my attempts to communicate with him and to bring him back into this case. He ignores my phone calls, my emails, my text messages, and certainly my letters. And at this point, with no communication from the client, I simply can't continue on as an attorney. There's nothing I can accomplish if he's not going to participate in his own case. He has not returned discovery. He has missed depositions that have been scheduled. And he's been, last time we were before you, Judge, if you remember, he was court ordered to answer State Farm's discovery request and appear for deposition within so many days. And he failed to do that. So he's not cooperating and he's not communicating. And there's really nothing I can do to advance this case on the plaintiff's behalf. So I ask the court permission to withdraw as his attorney.
Okay. Okay. So what the court does in these situations will grant a relief to withdraw, and the plaintiff has 21 days to retain new counsel and must appear for a special conference with or without counsel on, give me 1 second. On August 29th, Tuesday, August 29th at 11 o'clock. 29 at 11 o'clock a.m. And Ms. Mills, please be present. If he fails to appear, the court will entertain an oral motion to dismiss with prejudice.
Thank you, Your Honor.
And please, Mr. Ford, put Mr. Johnson's information in the order if there's a need for Ms. Mills to reach out to him so that she has that information, whatever his name, address, phone, last known address and phone number.
I will do that, Judge.
Okay, so Ms. Mills, just be present on the 29th at 11 o'clock. And if he fails to appear, the court will entertain an oral motion from you.
Thank you, Your Honor.
Thank you. And I'll look for the order today, Mr. Ford.
All right, thank you, Judge.
Thank you both.
Hi, Jessica.
21.
Charnay Stafford versus Allstate et al. 22013680 NI.
Council opinions for the record.
Morning, Your Honor. Nick Bellamente, appearing on behalf of defendant Allstate UMUIM.
Hello, Your Honor. Brian Patton appearing on behalf of defendant Retta.
Okay, Mr. Brennan, this is your motion. What's going on procedurally?
So this is defendant Allstate's UMUIM motion to adjourn the scheduling order to track 2. Apologize, Your Honor. The lawsuit allegedly arises out of a motor vehicle accident that occurred on December 9th. Plaintiff filed suit against multiple defendants alleging various claims, including auto negligence, owner's liability, first-party PIP benefits, and uninsured underinsured motorist benefits. On January 11th, intervening plaintiff, New Grace, filed an intervening complaint. And then defendant Allstate, we served our discovery on plaintiff on February 3rd, 2022. Since that time, we had significant delays in receiving plaintiff's discovery responses. In fact, we had a motion to compel that we filed at the same time as this motion to adjourn, but plaintiff responded to our discovery this Monday, so we removed it. We're in the process of ordering the records that plaintiff mentioned in his discovery. And once we receive those, we may need to issue follow-up discovery. Secondly, plaintiff's deposition was scheduled for July 14th in this matter. However, plaintiff had to reschedule. Since that date, all counsel has been corresponding with plaintiff trying to reschedule their deposition. In fact, as of today, co-defendants are still reaching out, trying to get some proposed dates to see if plaintiff would respond. Moreover, defendant Allstate corresponded with all parties, seeing if they would be willing to stipulate to track 2, and everyone consented to the adjournment. However, we never got around to actually filing a stipulated order. And then lastly, co-defendants Reginald Rippey and Marie C.R. Mills have yet to appear in this case. Defendant Allstate issued a subpoena to them, and our process server informed us that it couldn't be served. So we ran a skip trace and just got a new address in. So we reissued the subpoenas, and we're in the process of serving those. And I think what the co-defendants Reginald Ripley and Maurice have to say in this matter is pivotal to defendant Allstate's defense. For example, if they weren't at fault or if they maintained insurance, then
Okay, tell me this, were they served? Because I know they're named defendants. Were they served? Have they been served? Do either of you know whether or not they've been served? Because I know we don't have plaintiff here.
I believe we're in the process of serving them. We just reissued them after getting the address from the skip trace.
Okay. I'll give you one, plaintiff step must take place within 28 days. I need that in the order.
Will do.
Okay, and I'll give you Casey Val in November with discovery through Casey Val. And that's more than track 2.
Thank you, Your Honor.
Okay, I'll look for the order today.
Thank you for your time.
Thank you, welcome. Discussion.
This is Troy Piper versus Homeowners Insurance Company 230047557NF.
Council appearance for the record.
Good afternoon now, Your Honor. Katrina Hatari appearing on behalf of defendant homeowners.
Okay, and this is your motion to compel more specific initial disclosures and to compel signed authorizations.
So we have received the more specific initial disclosures from plaintiff, but we have not received the signed authorization. So we are still moving forward with just the motion to compel the signed authorizations.
Okay, well, we'll give them 7 days because you said 14 days, but they've been aware of this for some time now, correct?
Yes, they have.
Okay, so we'll give them 7 days to provide you with the signed authorization. Just present an order to the court will enter it.
All right. Thank you, Your Honor.
Thank you very much.
Have a great day.
You as well. No. We got anything else? What else we got? I have, I'm sorry. Let's see. Do we have Rollins? Physical Therapy Solutions?
Yes.
Okay, wait, give me 1 second. Do you have Palin, P-A-L-I-N-G? Okay, give me 1 second. What about Minge? Do we have Minge? Okay. Wait a minute. Do we have the last wait a minute? Do we have oh no, you're crazy. Okay, let's do we can do God. We can do Polly, then we can do Minge, and then maybe physical therapy solution. We can do Palin. What number is that? Yeah, get them. Okay. Good afternoon, Council.
Good afternoon, Your Honor. How are you doing today?
Good afternoon, Your Honor.
Fair to Midland. Ms. Clifton.
Brandy Paling versus InfraSource Construction et al. 220071881NO.
Council appearances for the record.
Allison, was that appearing for plaintiff?
Ahmed Shamsuddin here on behalf of defendant InfraSource.
Bo Rice on behalf of defendant City of Grosse Pointe Park.
Okay, Mr. Chairman, this is your motion, right?
Yes, Your Honor. But before I start, I'd like to make a record of something that happened during the week between the parties, if I may.
Yeah.
So last Friday, I appeared before Ms. Clifton, thinking my motion was last week, but we failed to serve a hard copy. So on that call was myself, plaintiff counsel, and Ms. Clifton, and she advised that I had to send a hard copy in. And I told her that the subject of the motion was to adjourn scheduling dates, which included case of L, which is supposed to occur this week. She indicated that she would reach out to MTA and that, she would suggest or try to get it moved. So late Friday afternoon, which would be the 21st, all of our offices got a notice that case of L was adjourned. And so come Wednesday, I get an email from plaintiff counsel that she was in case evaluation, that it was occurring, and that we responded saying that it got pushed. And I was not ready available to hop on, neither was attorney of record, Mr. Augusta. So they proceeded, they put numbers on it. And then I had to scramble and contact MTA and essentially void the awards and indicate that, you know, it got adjourned. And so I thought it was important for the court to know that before I make my argument for adjourning the scheduling order.
And I would like to respond to that briefly. I did appear also last Friday and told Kim that I was objecting to the adjournment and that I was not in favor of case eval being moved for a long time. And she said noted, and that she would talk to the court. When I appeared, and brother counsel can back me up on this, a case eval, they said they had no notice of the adjournment. I found that the email that was sent to my secretary who's on maternity leave and should have had an out of office respond back. So I never got the notice. I didn't know anything about the adjournment. Case eval didn't know anything about the adjournment. They said they had it on the docket and they said they intended to proceed.
No, Ms. Clifton just said that's not true. So I don't know what they told you. She's got an email.
She said that they later said that they had an email from her, but they did not have it at the time we appeared. The case eval clerk called all of the offices trying to get everyone to join so we could get it sorted out.
But if they weren't prepared, they weren't prepared because there was a motion to adjourn it. So it shouldn't have gone.
Right, but I feel like that he's accusing me of some kind of bad faith or bad acting. I appeared because I had no notice of the adjournment.
But that's your fault because you didn't have an assistant. She's on maternity leave, but the court had adjourned it. So I'm done with that. I'm done with that.
Okay, I just want to make sure that there's.
I'm done with that.
I did anything wrong here when I had no notice.
But that, like I said, I'm done with that. You know, I understand your situation, but it was sent to your assistant, so I'm done with that. So, Mr. Chesney, stop, Miss Lizette. Mr. Chesney, has the award was set aside?
Yeah, I emailed the MTA who Ms. Clifton had indicated. I think it was Ms. Rahman and Ms. Allen. They voided it as of Wednesday.
Okay, so what I'm going to do at this juncture is case eval is set for October with the scope of the case eval, but you're going to be responsible for the adjournment fee. So I'll look at the order, Mr. Chancellor.
Okay.
All right, thank you all.
Thank you very much, Your Honor.
You're welcome. Bye now.
Thank you, Your Honor.
Give me 1 second. What we do? Okay, you can call it.
This is Brian Minge versus Dana Ford, case number 220100044CZ.
Counsel appears for the record.
Good afternoon, Your Honor, and good afternoon to your staff. May it please this honorable court. My name is Todd Russell Perkins, appearing on behalf of Mr. Minge, the plaintiff in this matter. I believe I'm standing in for the attorney of record, but nonetheless, Adam Clemens is a lawyer at our firm.
Okay, so Ms. Ford, has Ms. Ford been served is she been served with the complaint in this matter?
I believe so, some time ago.
Okay, all right. So
yes.
the fact of the matter remains that at this point in time, she was supposed to provide discovery and has failed to do so?
Correct.
Okay, Ms. Ford, have you retained counsel or you represent yourself?
No, I'm representing myself.
Okay, so you need to comply with the discovery that he sent you. You do have that discovery request, do you not? I'm sorry, Mr. Perkins, do you know when it was initially served? Excuse me.
I couldn't hear you, Your Honor. I'm sorry.
Do you know when it was initially served?
When it was initially served, the discovery request?
Yes.
My law clerk's grabbing that. But it's been a long-standing issue, but I will find that shortly.
Okay, but it's outstanding for some time. So Ms. Ford, if you represent yourself, you have to ensure that you stay up on all these things. Miss Ford, are you on the e-filing system?
But I don't believe so.
That you don't know what I'm talking about. So you need to figure out, because if you represent yourself, you have to be abreast of all the things that this court operates on the e-filing system. Do you have an email address? If so, you need to call the clerk's office and determine how to get on the e-filing system. And
Yes, I have an email address, and
well,
I received something from the attorney, and I sent it back to him. He sent it through to me via email.
so what they have is they have answers and requests for admissions.
Right. I answered them and I emailed them back to him.
Did you email them to the court? We have to do
I
like
emailed them. I'm sorry, I emailed them to the attorney. Last time I was on the Zoom, I was told that I was supposed to email him, answer him, and email him back to the attorney.
But you have to file them with the court as well. So, Mr. Perkins, did your office receive anything to your knowledge?
My law clerk is in here and said we have not received it. If we had, we wouldn't.
Right.
It was an order dated from February 21st of this year. Set with 7 days to comply, and that didn't happen. So that was
you're
the
saying,
initial order.
okay, you say the court signed an order?
Yeah, there was an order. It has failed to comply with an order dated February 21st of 2023, and that was the reason why we filed this show cause.
Okay, Ms. Ford, you have to get the responses to the plaintiff's counsel. You know, if you said
yes, I'm pulling up the email now where I sent them. So it looks like I sent them on the February 28th at 10:09 a.m.
Who did you send them to?
A Clements at perkinslawgroup.net.
Mr. Perkins, you're on mute. You're on mute.
If that's the case, then Mr. Cummins is not in town right now. But if that's the case, we will withdraw it. But I don't know. I don't think that.
Okay, so you need to resend it now. And Mr.
Okay, I'll resend it now.
Mr.
Perkins, I'm sorry.
Mr. Perkins, just use the same email address, or do you want her to use someone else's?
If she could use mine also, or tperkins at perkinslawgroup.net, that would be great.
Did you get that, Ms. Ford? Perkins
at perkinslawgroup.net.
Yes.
Is that correct?
Yes. So, Mr. Perkins, I'm going to put this over for a week and just let Ms. Clifton know beforehand.
I will.
I'm sorry, she said August 11th at 10:30. So we're just
We still have the settlements conference with you next week, or are we going to adjourn that since we haven't?
No. Okay, what date is that? Give me that date so we can put this together.
I think it's the 1st, if I'm not mistaken. I'll look on my calendar.
Okay.
I think we are up before you. Yeah, we're up at 11 a.m. for a settlement conference, but clearly we're not done with discovery. Yeah.
August the 1st? August
the 1st, yeah.
Okay, so we'll come then and we'll have discussion about discovery and whatnot. And Ms. Ford, get Mr. August 1st. I'm sorry, Mr. Perkins, my mind just blanked. August 1st at what time?
11 a.m.
Okay, so like I said, get that to Mr. Perkins today. He'll see what it is, and you need.
I just sent it.
And you need to be at the summer conference via Zoom on August the 1st at 11 o'clock, and we'll deal with the discovery issues and see where our procedure lead then. Thank you very much. Have a good weekend.
Thank you.
And
thank you.
We'll just put this over to them. Thank you.
All right. Thank you so much.
You're welcome. Okay, we can do Rollins. What would it? I'm sorry, wait, give me a second.
Good afternoon, Your Honor.
Let me see. Okay.
Ms. Smith, is this your motion
Yes, it is.
to dismiss?
Keep on it? No, okay. All right. It's her motion, right? Okay, go ahead.
This is Physical Therapy Solutions versus American Economy Insurance Company et al. 22006-668NI.
Good afternoon, Councilman Prince, for the record.
Good afternoon, Your Honor. Shanavia Smith on behalf of defendants, American Economy, Liberty, and Safeco.
Okay, and just to make sure I'm on the right track, the court previously granted a motion dismissing the primary plaintiff's case, correct?
That is correct.
Okay, and we did not receive any response today, correct?
From plaintiff's counsel,
Yes.
I received a response that was filed. I received it on the 14th, but I don't see, is plaintiff's counsel here? I don't see them.
No, we don't have anyone else that's checked in on this. Okay, and the court's just gonna make a record, even though the plaintiff has filed a response, the plaintiff is not here. This matter was set for 10:45, it's now 12:54. The court previously dismissed the primary plaintiff's Rollins case with prejudice for failure to comply with prior court orders. The court relied on and utilized the deemed factors in reaching its decision. Therefore, based on the fact that the intervening plaintiff stands in the shoes of the primary plaintiff and the dismissal of the plaintiff's underlying claim operates as an adverse adjudication on the merits according to the statute, and the intervener is subsequently barred from proceeding with a derivative claim, and that is based on DeWolf versus State Farm of Michigan, 317 Mich. Ave. 517. That being said, the court is satisfied and the court will dismiss the plaintiff's intervening claim with prejudice. And Ms. Smith, please prepare an order and present it to the court for entry. And that will therefore dismiss and close this matter in its entirety and put that this is a final order in this case.
Thank you so much.
Thank you. I'll look for the order to be submitted today.
Okay.
Thank you.
Thank you.
Mhm. I got two motions. Okay. Give me one second. I think Charles, what to put the proofs on? Is Charles the one with the conservative? Yeah, let's do that. Good afternoon, everyone.
Good afternoon, Judge.
Ms. Clifton.
Kenneth Chaw et al. Versus Henry Ford Hospital, case number 210100908NH.
Council appearances for the record.
Thank you, Your Honor. Judy Suskin on behalf of the plaintiffs.
Hi, Your Honor. Tony Paradiso on behalf of defendant.
Okay, and this is our date and time set for the court's approval of the confidential settlement. That being said, Ms. Suskin, what I will allow you to do now, the conservator, who are we dearing here?
Well, the plaintiff is a protected person. Suzanne Chall is the guardian and the spouse of Kenneth Chall. Janice Sirens is the conservator and the daughter. And I plan to take testimony from both so that, you know, we don't have any issues. Okay. And they're here today, as well as Mr. Chall.
Okay, thank you very much. And that's Miss Suzanne Chall and Miss Jana Ciernas, right?
That is correct, Your
Would
Honor.
you both, you're on mute, ladies. Could you please unmute yourself first?
There we go. Sorry, Your
Okay.
Honor.
Okay, could you both raise your right hands, please? Do you solemnly swear or affirm to tell the truth, whole truth, and nothing but the truth?
I do. I do.
Thank you very much. Ms. Sussman, you may proceed.
Thank you, Your Honor. Ms. Chall, you are the guardian and wife of Kenneth Chall, correct?
Yes.
Okay, and state your name for the record if you would, please.
Suzanne Chall.
And Ms. Sirens, you are the daughter and conservator of Kenneth Chall, is that correct?
Yes.
And please state your full name.
Jana Charlotte Sirens.
And you understand that right now pending before this court is a lawsuit, a medical malpractice lawsuit regarding Kenneth Chall for injuries he allegedly sustained during a cardiac cryoablation procedure at Henry Ford Hospital back in August of 2019. You understand that?
Yes. Yes.
Okay, and thank you. You understand that if the court today is it going to approve the settlement, the confidential settlement that's been reached between the parties, that you will never have a chance to bring this matter to court for a jury deliberation or for the judge to determine what, if any, damages are due and owing to Mr. Chall and you. You understand that?
Yes. Yes.
You understand that if the case did go to a trial, you might get more than the amount of the settlement. You might get less or nothing at all, but you won't have that chance to bring the case to a trial if the court today agrees to approve of the confidential settlement.
Yes. Yes.
All right. You understand that by agreeing to the settlement, Mr. Paradiso's clients have not raised their hand and admitted fault in any way, but they've agreed to a compromise and agreed to this settlement to conclude this matter. You understand that?
Yes.
And you understand that one of the conditions of the settlement is that this is to be kept confidential, that the terms of the settlement are not to be disclosed to anyone. You understand that?
Yes. Yes.
And you are willing to abide by those terms?
Yes.
You understand that you will be required to sign a release that releases the defendants of all liability in this matter with your signatures in order to have the settlement finalized and receive a check.
Yes. Yes.
All right. And Your Honor, I don't know that I have any further questions about the actual settlement. I do have further questions about distribution of the settlement proceeds, and I'll be using the confidential Exhibit A that I've already provided to the court. My clients have that document, and Mr. Paradiso, I believe, has that document as well.
Okay.
If I may further proceed with that, unless Tony, you believe I've left anything out with regard to your end.
No, I'm assuming you're going to cover any outstanding liens as you cover. Yeah, no, I'm good.
And thank you. All right. You understand that the amount of the confidential settlement is on this Exhibit A. And I'm going to just refer to that document, ladies, while we go through the rest of this. The total settlement is on the top line of the confidential Exhibit A. Is that the settlement that you have agreed to accept to conclude this matter?
Yes. Yes.
And below that line are the attorney costs. When you hired me and my law firm, there was an agreement that the attorney costs would come off the top. That's on the next line. I don't think that's confidential, but I'm proud of the fact that we were able to keep those costs where we have them. You approve of those costs to be reimbursed to the Summer Schwartz law firm pursuant to our contingency fee agreement?
Yes.
And you also approve of the attorney fee, which is on the third line of the confidential Exhibit A, to be given to Summer Schwartz for our services rendered in this case?
Yes. Yes.
And the next line is the settlement minus the attorney fees and costs, but you understand that there are some medical liens that we have the responsibility to pay back. And those are indicated in the next section of confidential Exhibit A. You understand that with regard to the proceeds received from the settlement, the amount of $97,229.19 will be reimbursed for Medicare or CMS for medical bills paid in this matter for Kenneth Charles care.
Yes. Yes.
And you understand that United Healthcare, AARP, is claiming a lien in the amount of $546.34 for their portion of medical bills paid to Kenneth Charles regarding the injuries relevant to this case.
Yes. Yes.
And do you approve of the liens being paid as outlined on this document?
Yes. Yes.
There's also, because of the need for probate services in this matter, Jennifer Harvey has served as your probate attorney. Is that correct?
Yes. Yes.
And she has claimed a lien for her services in the amount of $1,655.70. Do you ladies approve of that amount being provided to her for her probate services?
Yes.
All right. And then you understand that there's a bankruptcy right now, and that there is going to be a need for at least another approval by the bankruptcy court before we can disperse your proceeds, because there is going to be potentially a dispute between creditors and the portion that goes to Mr. Chall and to you. You understand?
Yes. Yes.
And Your Honor, there's another lawyer, a bankruptcy lawyer. I think it's in the motion outlined that Leon, I always butcher his last name. It's Schmelzer.
Don't feel bad. We butcher it too. Meltzer, I believe. Smeltzer.
Yes, thank you so much. He's handling that portion. So today, if the court is amenable to approving of the settlement, the amount after the attorney fees, costs, and liens will be set aside until further direction of the bankruptcy court so that they can handle that portion of it. It is not under the jurisdiction of this court to do so, but I am obligated to honor the trustee in bankruptcy, the creditor's claims, et cetera. I've gone through all of the proper procedures, and what they tell me is that Your Honor has the authority to approve of the settlement, the costs, the fees, and the liens, and the rest will be then left to be distributed as further directed by the bankruptcy court.
All right, thank you. Mr. Paradiso?
I don't have any further questions. I believe Ms. Susskind covered it all.
Okay. Based on the representations placed on the record, the court is satisfied and the court will approve the confidential settlement, attorney fees, costs, and liens as set forth in the confidential document. And as Ms. Susskind indicated, the court will refer this matter to the bankruptcy court to resolve all of its outstanding issues and to make final distribution. So,
yes,
and we'll look for the order from the court approving the settlement, and then you can go forward with the bankruptcy court. But thank you all. And have a great day.
Your Honor. Thank you, Your Honor.
Thank you, Judge. Thanks, everybody.
Thank you.
Thank you.
Bye-bye.
Bye.
We can do we have I'll do this. I don't know. First National. Yeah. Good afternoon.
Good afternoon, Your Honor.
First National Bank of Omaha versus Karen Parsons, case number 230036955CK.
Counsel appearance for the record.
For the record, Your Honor, Albert Kim, P70301, appearing on behalf of plaintiff in this matter.
Ma'am, would you state your name? Ma'am, would you state your name, please?
I'm sorry, Karen Parsons.
Thank you. Mr. Kim, I had an issue with the way this was filed because one, I don't know, and I looked at it, I don't know, you don't have in the motion, what's the basis of the default, what's being defaulted in, and what relief that you're asking for. So I just, I was at a loss, and then there's no affidavit supporting anything. So what is it? What's the nature of this claim? Because I think you're probably gonna have to refile this. I don't know what's going on.
Well, Your Honor, the basis is, again, this is a credit card action. Defendant was served with the documentation, failed to file a responsive pleading, and default was entered. And at that point, we were seeking default judgment to be entered. However, obviously, if Ms. Parsons is here, ideally, I'd like to try to resolve it with her directly if I could. So
Okay, so what we're
maybe
gonna
I'll
do,
use this as an opportunity to speak with her, and then maybe we can get this matter resolved and get it off the court's docket.
okay, so one thing, Ms. Clifton will give you an invitation to a breakout room. You can go into the breakout room. Because if you can resolve it, fine, otherwise we'll have to put it over, because I don't have any supporting documentation attached to your motion relative to an affidavit about the amount that's claimed, which credit card it is, and so forth and so on. You just said refer to the complaint, and that information has to be set forth in the
Understood,
motion.
Your Honor.
So Ms. Clifton will send you an invitation, so look for the invitation, go to the breakout room, and then Ms. Clifton will come back and check on you and bring you back in. What I'll do for you first.
Hello, Your Honor.
Hi, Mr. Miller, how are you?
Oh, hold on.
Good afternoon, Your Honor.
Ms. Albert, Ms. Clifton is going to call the case.
This is Norman Fournier versus ThyssenKrupp, case number 22008-444-NO.
Council appearances for the record.
Neil Miller, Your Honor. I represent Mr. Fournier.
Armin Howlovich on behalf of defendant ThyssenKrupp, Your Honor.
Okay, and Ms. Albert, this is ThyssenKrupp's motion to dismiss.
Yes, Your Honor, that is correct. We generally prefer not to file these type of motions, but in this particular case, the plaintiff's answers to our discovery are almost 5 months overdue. And we've been greatly prejudiced in our ability to complete discovery due to that fact. After repeatedly asking the plaintiff for the answers to discovery, we finally filed a motion to compel on April 14, 2023. The plaintiff did not respond to the motion, did not answer the discovery in response to the motion, and this court ultimately entered an order compelling the plaintiff's answers by May 16, 2023. And despite this court's order, the plaintiff again failed to answer the discovery. And despite numerous requests for the discovery before filing this motion to dismiss, plaintiff did not provide answers to our discovery until yesterday evening at approximately 5 p.m. I have not had an opportunity to review the plaintiff's answers to make sure that the answers are complete, but I will note that the interrogatories were unsigned and the court's order specifically required the plaintiff to provide full and complete answers under oath to our discovery. Now, given the length of the delays and the many reminders and extensions of time already provided, the plaintiff's conduct in this specific case evidences a flagrant and wanton refusal to facilitate discovery, such that the sanction of dismissal is warranted under these circumstances. So despite the plaintiff providing the answers yesterday evening, we would ask this court to dismiss plaintiff's claim because the answers were due by May 16th.
Your Honor, I don't believe in filing these discovery motions. Typically try to work it out. Yes, I was very late. They've not been able to produce the their employee who caused the accident because he won't testify. I've granted them innumerable adjournments in getting them initial disclosures out and getting me my initial discovery. My client cooperated fully, attended a deposition. I've provided them with over 50 pages of documentation that doesn't include the medical records, which we provided informally, either to the adjuster or to defense counsel. So, the motion is overblown. I realize that we're late in filing discovery answers. Dismissal is just not the warranted remedy here.
Okay, tell me this, why aren't they signed?
Because my client they're not signed because I didn't get them to my client in time to sign.
So, Your
Didn't
Honor,
sign by Monday, Your Honor.
if I may respond, Your Honor. First of all, we haven't completed the plaintiff's deposition due to the fact that we haven't received the answers to discovery. So I'm not sure where that's coming from.
You have completed it. You haven't completed I thought you took my client's deposition.
Absolutely not. And that's why we've been prejudiced by this. We still need to complete the plaintiff's deposition. And most likely we'll need to conduct follow-up discovery. And now we're in the situation where the discovery cutoff and the case evaluation is in less than 2 weeks. So this has greatly prejudiced our ability to defend this case. And that's why we filed this motion to dismiss. And it sounds like the plaintiff didn't even answer these interrogatories because he didn't sign them. The answers are likely to change once he gets to review them. So
the answers were prepared in a teleconference between me and my client, Your Honor.
Okay, but this is what I'm going to do. Mr. Miller, since it took you so long, you have to pay the defendant $500 in costs within 30 days. Signed answers by Monday.
Okay.
And give me one, let me gather my thoughts. Give me 1 second.
Your Honor.
Yes.
Could we also get an adjournment of dates?
Okay, hold on. I told you, let me gather my thoughts. Let me gather my thoughts, please. Right now, you guys are already on track too. I'll give you case evaluation in October with discovery through case evaluation.
Thank you, Your Honor.
And there'll be no further adjournments. Mr. Melvin, you need to put this all in your order.
Yes, Your Honor. Is there any way, Your Honor, that we could include language in the order indicating that any late fees relating to the August 7 case evaluation are waived? Because technically we're supposed to go to case evaluation within less than 2 weeks.
Give me 1 second. Give me 1 second. Plaintiff is responsible for any adjournment. Case eval fees.
And Your Honor, just one last thing. Is there any way that we could indicate in the order that the plaintiff has to appear for a deposition within 45 days?
You guys have said his deposition. We've never not cooperated in
Well,
discovery.
to complete it, to ensure that it's completed 30 days.
Okay.
Deposition is to be completed, not appear, because it's my understanding that, so Mr. Albert, you're not starting from scratch. This is a continuation, correct?
Your Honor, my understanding is that we
just, did he appear for a deposition?
Maybe he didn't, Your Honor, but I know it was said. It's not that he didn't appear, it's just that we didn't take the dep, that's all. Not a question of not cooperation.
Ms. Halibut?
Your Honor, we did not take the plaintiff's deposition.
Okay, all right.
We've been taking other depositions all along, Your Honor.
Okay, plaintiff's dep within 30 days.
Okay, Your Honor, I'll prepare the order and submit it today.
Okay, thank you both.
Thank you.
Thank you.
Mhm. Okay. Okay, Mr. Kim, where are we now?
Your Honor, I did have an opportunity to speak with Ms. Parsons. She's familiar with this account and she admits liability. However, she is likely and has retained bankruptcy counsel on this matter. I don't know how the court would prefer to proceed. I'm fine with pushing and this matter for 45 days. And if we need to refile our motion, we will. Maybe put this up for a status, but in lieu of the amount owed on this card, I find the claim to be credible. So,
Okay, so, what is this? Are we doing? Give me one second. This is probably going to be pushed to September. What's the first day in September? That we're using. September 8th at. September 8th at 9:45.
and Your Honor, we issue the motion with the appropriate exhibits and changes, of course, as well, if we have to proceed.
All right, just make it an amended. Okay, so September 9/8 at 9:45. And like I said, if it's going to, is that what I said, Ms. Cook? Oh, I'm sorry, 9:45, 9:45, 9:45, I'm sorry. September 8th at 9:45. And as you indicated, Mr. Kim, you need to ensure that you have the credit card information in there, the amount of the debt, as well as an affidavit from your client.
Very well, Your Honor.
Okay, just consider the title of that amended motion. Okay, all right. And then, of course, since he's doing an amended motion, does he need to do another renotice? Since he's amending his motion, Ms. Clerk? Yeah, that's okay. So we're fine. Okay, so
Just the amended motion, Your Honor.
yes, yes.
Very well.
Okay, if not resolved, we'll see you on September the 8th at 9:45. Thank you very much.
Thank you very much.
Hello, Your Honor.
Hello, it's been a long day, but we're gonna work through this because I'm like, okay, we got this and we got that. Do we have, okay, Mr. Tangelo, okay, let me.
Good afternoon.
Ms. Clifton.
Lent Chiropractic PC, Taniqua Smith versus Allstate, case number 23001144CZ.
James Tantalo on behalf of Lint Chiropractic.
Good afternoon, Your Honor. Christopher McDonald appearing on behalf of the defendant, Allstate.
Okay, so when I looked at this, I said, okay, we've got the motion to leave to file a response to the motion for reconsideration. Then we've got the motion for renewed response to the motion for why, if we gotta do, don't we have Mr. and tell me, Mr. McDonald, don't you agree that we need to deal with the motion for reconsideration first? Was there another motion for summary disposition?
So yes, there's a motion to strike plaintiff's renewed response. I think Mr. Tantalo might be able to explain it the most because we had some confusion as to it too. And we just wanted clarification from the court that this is not some sort of amended or supplement to plaintiff's original response to defendant's motion. Based off of the response that was filed by plaintiff to this motion, it appears that they're indicating that it was supposed to be some sort of supplemental brief to its brief for its motion for recon. However, it wasn't immediately clear based on the nature of its filing.
Mr. Tangelo.
So the timeline of events Judge, was that on May 12th, you had issued your order granting defendants MSD and dismissing the case. 2 weeks after that, on May 24th, we filed our motion for reconsideration, which did include a renewed response to the MSD, to the underlying MSD. On June 9th, defendants filed their motion to strike, as well as their motion for leave to file a response to our motion for reconsideration. So that's just the timeline. I think that we're all in agreement about that.
I agree.
But I did want to clarify that our motion for reconsideration, although it may be perhaps structured unusually, it did include a renewed response to our motion for summary disposition. The filing included the motion itself, a brief, and the renewed response. The parts were all part of the same filing, and they were organized in this way with the aim of clarity and understanding. Our motion for reconsideration does conform with 2119, which governs motion for reconsideration, and our filing was in full conformity with all other rules governing motion practice, such as the full filing, all-inclusive, was less than the maximum page limit. But importantly, our motion for reconsideration, as well as the renewed response, presents new issues not already ruled on by the court. For example, and of course, that is fundamentally what is critical in a motion for reconsideration. But for example, it goes into greater depth on some of these, on some of the Candler factors, and offers some additional questions and issues that were not addressed by the court in the.
Okay, do you know what? And I'm looking through my the court filings. I don't remember that, to be honest. And we never received a hard copy, because I see all this going back and forth, but the court doesn't acknowledge any pleadings in its court until it receives a hard copy. And I note that you filed your motion for reconsideration on May 24th, and you guys were going back and forth, scheduling, rescheduling, so forth and so on. But I never received a hard copy, so the court would never entertain this until I receive a hard copy.
Okay, well, that's an error that we can remedy immediately.
As you indicated, your pages of your pleadings were within the appropriate time frame. But like I said, let me see, previous. Right, because I'm call me old school. I don't like flipping through all these pages, so to speak, and I write notes. So that's, call me a fossil if you will, but that's where I am.
Judge, I would never, and in light of that, perhaps this compromise could be offered. We will remedy that mistake right away. We'll make sure that a hard copy gets to you immediately. And then perhaps with that satisfied, we can pick this up again at a time that's convenient for the court.
Okay, so let me say also, Mr. McDonald, I do have hard copies, but I don't know how you want me to deal with this. One, I will grant you, deal with this one. I'll grant you leave to file a response to plaintiff's motion for reconsideration.
Thank you, Your Honor. For the renewed response, I don't think there's going to be any issue, but again, without this judge's ability to review it and confirm, unless you want to make some sort of ruling stating that this is inapplicable to plaintiff's initial response to defendant's motion. Again, it seems like it's supposed to be just an extension of their brief to their motion for recon, but again, I can't show that to you without you having it in front of you.
Okay, so what I'm saying is at this juncture, all I'm going to do is say, and then I'll probably give you a hearing date, but what I'm going to do is give you the opportunity to file a written response, and of course, provide the court with a hard copy, because like I said, I don't, you've got and I think that in your motion reconsideration, you're gonna have to address really all of the things that you raised in these two respective motions. Well, one, I'm granting you the relief, and then you also filed your response, you had the motion to strike the renewed response. So to me, I don't want to practice law for you, but I don't think that it's right at this time, because what we need to do is deal with the motion for reconsideration. And if you feel, and I'll just say that's part of your response to the motion for reconsideration to strike whatever else, then that should be within the motion for reconsideration. Are you following me? Does that make
I
sense?
am, Your Honor.
Let me know if that makes sense to you.
Yeah, it definitely does. And again, I really do think after this court has time to review the motion for reconsideration, all of this will be extremely clear. My suggestion would almost be to adjourn the motion to strike until the court gets the hard copy and can actually review what's within the motion for reconsideration and the additional document that's entitled the renewed response.
Okay, so let's do this. As I indicated, you can present an order indicating that you do have relief to file a response. And what I think I'm going to do is I'm going to give you a hearing date now, but Mr. Tantalo, you're going to have, when you file your motion reconsideration, you're going to have to do your office is going to have to do a press appeal and all that stuff. Ms. Clifton has stepped away, so
Very well.
I can't begin to, I stay in my lane. So let me try to get you a date. So, Mr. McDowell, will you file a separate response?
Yeah, so that was just our motion for
Okay.
leave. I will file an actual response.
Okay, great. Let me get you a date for the hearing on the motion. Okay, let's say, oh, no, it's beginning. 1, 2. Okay, let's say August the 24th, Thursday, August the 24th at 2:30. So that's for the motion for reconsideration.
Okay, and Judge, you're saying that I should press a fee for that date and time?
Yes.
Okay, very well.
And Mr. McDonald, put that in your order.
Absolutely. And I'm assuming in the order you would also like that the motion to strike is set for that date also.
Yes, yes. And whatever pleadings you file, e-file, you must get the court hard copies in advance. Must. Okay.
My apologies.
That's all right. that's what led to, I guess, some of my confusion. Okay, all right, so Mr. McDonald, I'll look for the order relative to your ability to file a response and the hearing date for the motion reconsideration.
Absolutely, Your Honor. Thank you so much.
Thank you both. Have a good weekend.
Have a great weekend, everyone.
Thank you.